Maarten, I'll start with you. Do you think it's a happy outcome what we came up with yesterday? Because there are some unions saying the tribunal was too lenient. I know that the Competition Commission had initially approved this merger with no conditions and then later asked for retrenchments last year to be reinstated. But do you think what we came up with yesterday should satisfy all parties?
Stephen, I do think it's a happy outcome. I think everybody got something. The government departments most probably didn't get what they wanted, and some demands of the unions weren't acceded to. But I think eventually, at the end of the day, employees will be re-employed that were retrenched previously. There's commitments on agreements, there's commitments on future growth in the organization and in the country for that matter. And ultimately, I think we should be happy with the outcome.
From your perspective, having represented Walmart and Massmart, happy with the end result?
Firstly, I think I need to say I'm not authorized to comment on behalf of the merging parties, but from the perspective of what Maarten said, I think the tribunal's decision is more than fair. The merging parties contended throughout the hearing and maintained persistently that there was no need for any conditions of any basis, given that the public interest concerns that were raised by the unions and by government had no basis in fact, and the undertakings that the merging parties were willing to give on a voluntary basis were simply that, voluntary undertakings, which we think went further than the tribunal actually had to go in placating them.
How easy is it going to be, Maarten, though, to measure the success of some of these undertakings? So, for one, perhaps the training of local procurers, and also on the job side, who measures this? Who's going to keep tabs on them to make sure that they actually deliver on what they have promised?
Sure. The Commission has an obligation to monitor these conditions. We've actually just started conversations about this, and we constantly monitor all types of conditions that the Commission and or Tribunal imposes on parties. This is not unique. So we've got a duty in that, and we'll be definitely engaging and making sure that happens. And to some degree, there's a self-monitoring mechanism, in particular in the fund that's been created, by getting representation from different stakeholders to be part of it. So any small business forum, for instance, would say, listen, there's not enough focus on small businesses. They'll come up, they'll make it known to the Commission, and we'll look into it.
Of course, Justin, we've heard South African government saying that it could take legal action, if conditions imposed on Walmart's bid for Massmart are not enough to prevent large-scale job cuts. They're saying government reserves its legal options at this stage. What are we potentially looking at there?
Well, government's obviously entitled to exercise whatever legal rights that it has. One of the potential outcomes is that there's an appeal. Questions of ability to bring the appeal obviously arise, and if and when an appeal is lodged, to the extent that government thinks that that's the route that they want to take, the parties will obviously have a look at it and decide how best to take it forward. But it's quite important to know that in the competition context, an appeal doesn't necessarily, doesn't stay the decision of the Competition Tribunal, and that will still then be in force. And the parties will still be able to implement the merger on the basis of the conditions that have been imposed.
Are we looking at further delays here to the process, Justin?
Well, I think what I've just said is that we don't anticipate any further delays. If the appeal is lodged, to the extent that it is by any party who's entitled to bring an appeal, and that obviously is something that needs to be considered by the parties who wish to bring an appeal, then the parties in competition law are still free to implement the transaction. It's a little different from the position in the High Courts, where when an appeal is lodged, the original decision is automatically stayed. The position is not the same in the competition authorities.
Of course, there are various conditions having been imposed. There's a local supply development condition that's been imposed as well. And with Walmart now in the picture, Massmart's food business has been earmarked to grow 50% over the next 5 years. Grant Patterson, CEO of Massmart, joined us on the line from Bentonville, the headquarters of Walmart in the US, to discuss local procurement in relation to the food side of the business.
As we've said many times, there isn't really a global Walmart procurement system in terms of the decisions of where product is sourced. What Walmart always help with is they help with quality, identifying ranges, and giving us processes and technology with which to work very closely with suppliers. I think it would be of no surprise to any of your listeners to discover that tomatoes and cabbage and lettuce and meat and eggs and the like it's all based on a commercial basis to source that not only in the country in which you operate, but as close to the stores as you operate, as freshness is key, and the cost of distribution is probably the most significant.
Maarten, do you think some of the conditions imposed on this merger could set the way for mergers and acquisitions going forward? So where we have this training of local procurement coming through, and when we have saving of jobs, is this going to be something that the Competition Commission will actually take into consideration when it considers future cases?
Stephen, we respect the decision of the tribunal. We consider their we consider their opinion quite high. We'll look into it where required. The tribunal did, however, make it clear in their press release, for instance, that we must be very clear about what is the remit of the competition authorities when it comes to public interest. And we'll be focused on that. We'll make sure that we don't go beyond our jurisdictions. Lawyers like Justin and others would obviously bring us back to our territory, which we are earmarked to look at. But where it might have an impact, we'll definitely explore options to do this. This was a voluntary offer from the parties, which the tribunal accepted and rolled out, which was possibly a means of trying to keep everybody happy in some regard. So we'll explore the options, definitely.
What sign do you think, Maarten, this now sends to the international investment community when it comes to investing in South Africa? Because it has come after much wrangling. Also, in addition to that, we've got Massmart having to spend 100 million rand on a program to develop now local suppliers, and that meaning or sending some kind of signal that costs and difficulties of investing in South Africa are possibly great.
That is possibly true, but I do think the message that is being sent out is that we are open for investment. We want investment. These conditions came voluntary from the parties. I don't think it's an overburdensome requirement on the parties to make these investments. It will be to their own benefit, as been admitted by Mr. Patterson. So I do believe that it's not a negative message that's going out. I think it's a responsible message that's going out, that firms should be looking out for their suppliers, and they should be looking out for the interest in the countries in which they're operating.
Justin, your view on how this process has gone forward, because obviously it's been an emotional case. It's been in all the media playing it up, of course. I mean, compared to previous cases that have been taken before the Commission and the Tribunal, how has this one gone for you?
It's obviously been a very interesting case. It's taken up a lot of my time since October last year. And
I'm sure you've all been earning good wages on this.
No, not me. I'm a lowly lawyer. But I think the process has been a very interesting one. Obviously, it did raise novel issues of government's involvement in these types of processes. And what's comforting for me, particularly, is that it has been a very inclusive process, a very rigorous process. The tribunal allowed for participation by numerous parties, which was not necessarily a requirement in terms of the Act. It was more inclusive than the Act required of it. And throughout that process, what has shown to be the case is that the Competition Commission and Maarten and his department and the Competition Tribunal have proved themselves to be entirely independent, operating within their mandate within the Competition Act, and not willing to be bowed by political pressures to the extent that they fall outside of the remit of the competition authorities.
Of course, if we look at the glass half full here, Maarten, I mean, to what extent does this partnership provide South African suppliers with an extended market here, and how do they actually leverage off that opportunity where we are looking at potential for exposure to an export market?
Well, I mean, what we've heard in the tribunal is that there's an anticipation of significant growth in South Africa and in Africa. And if some of those local suppliers can latch on to that growth, it will be to their benefit, and they will be able to create jobs. It will be to the benefit of local manufacturing, local employees, trade unions, as well as African countries as a whole.
Maarten, so Justin, you want to tell something?
I mean, I think certainly during the course of the hearing, the merging parties contended that from a commercial perspective, local procurement is something that they would be keen to maintain. And from that perspective, this fund that you've mentioned, the 100 million rand, it's of a commercial benefit to the merged entity, and one would think that if parties are able to make use of that, it benefits suppliers through a relationship that Massmart, well, the merged entity and those suppliers can jointly move forward in a way that's beneficial, mutually beneficial to all of them.